Good luck.
Hi, good morning, everyone, and welcome to the third of our series of webinars in connection with different events that are happening in a very changing time and challenging time for everyone. Obviously, this morning is the first day of lockdown again on level 5, and that's going to have serious effects for many businesses and also obviously on society as well. In relation to businesses, it's opportune that we should be looking this morning at the effects from a corporate restructuring and debt resolution point of view, because these are things that are probably going to affect a number of businesses in the near future. Of course, we'll be looking at a lot of businesses have been surviving on government supports, and those government supports have been extremely beneficial and very helpful. But as we go into a new lockdown, I think some of the supports have changed, and in particularly the one in connection with the TWSS as opposed to the EWSS. So the temporary support scheme was very beneficial. A lot of companies benefited from it, and it supported them and allowed them to keep their workforce and their cash flow very secure. While the EWSS, the criteria are slightly different, and companies are businesses that may have had a good 3 months trading and are now facing closure, and a potential good December, if it comes back again, may not qualify for the EWSS and may end up with some difficult decisions in relation to retaining staff for the next 6 weeks and maintaining cash flow. So these are very topical issues and things that companies are dealing with and will have to look at in more detail over the next while. This morning we have our own partner, Declan DeLacy. He's our corporate restructuring partner. He's been with the firm for 8 years at this stage. He has been involved in many high-profile liquidations, and he has done examinerships, both members voluntary and creditors liquidations, and also examinerships. We've been joined as well this morning by Aisling Murphy, who is a partner in O'Shea Barry Solicitors. Aisling specialises in litigation and dispute resolution, including commercial, insolvency, property and employment disputes. She has advised debtors, directors and liquidators and shareholders on both contentious and non-contentious insolvency issues. So it is great to have Aisling with us this morning to give a legal view on these type of things and how they will evolve through the courts. So I think the presentation will be jointly by Declan and Aisling as we go through it. So I'll hand you over firstly to Declan to begin the presentation.
Good morning, everyone. And I suppose on this, the first day of our new lockdown, I suppose I should say happy lockdown. I'm going to move the slide on there. I suppose as we start this presentation off, I think it's useful before we get into the detail of I suppose the difficulties that individual companies are facing and the solutions that might be available to them. It's useful to look at a macro level how the economy is doing overall. And with that in mind, what we've done is we've extracted some figures from the central bank's quarterly bulletin, and then from some of the earlier material produced by the central bank and some notes by the revenue. And setting the scene, the central bank in October of this year are predicting an overall economic contraction this year of 7.1%, which is very significant and certainly a total reversal of what we have been seeing over the last 4 or 5 years, where we've had good growth. They're also expecting overall employment to fall by 4%, and indeed in August of this year, they're saying that COVID adjusted unemployment reached 15.4%, which is an enormous level. And you have to go back to 2012 or 1995 to see similar levels of unemployment. Concerning for future growth is the fact that investment in the economy has dropped by 35%. and very concerning for SMEs, is that the central bank said in March that over half of them had less than 1 month's turnover in cash reserves. It's very difficult to imagine that in the absence of some of the supports we've seen from the state over the last few months, that cash wouldn't have dwindled to a negative position in the meantime. Central bank are also saying more recently that 16% of Irish SMEs are in serious financial distress. And what they mean by that is that they're not able to pay the interest on their borrowings, leaving aside the capital, and their fixed costs. And the revenue have recently announced that 70,000 businesses are warehousing tax. And the amount of PAYE and VAT that has been warehoused is 2.1 billion. And that's an extraordinary statistic if you consider that that really means that 70,000 businesses are not in a position to pay their VAT and PAYE as they fall due. What you'd expect from all of that, if I move forward here, is that we would be seeing a surge in liquidations. And indeed, if you go back to March or April, I was expecting that we would be up at about 1,000 liquidations this year, but that hasn't materialized. In fact, if you look at the graph you can see on screen there, you'll see that over on the right you have the number of insolvent liquidations in Ireland between January and September of this year, and then preceding years over in the columns over on the left. And of course, the numbers of liquidations peaked at about 1,400 in 2011 and 2010. But to find a year with as low a number as 2019, or where we're expecting to see 2020 being, you've got to go back to around 2007. So the middle of, or the end of the boom, when it was as boomy as it got. So it's extraordinary in the context of the slide we looked at a moment ago to think that we are heading into a record low number of liquidations this year. And I suppose that begs the question, why are there so few? I suppose there's a couple of reasons around that. I suppose as we entered into the first lockdown in March, we all thought it was going to be for 2 weeks, and as things have developed, we've been told that everything is only going to be for a short period, and things will return to normal after that, and that hasn't happened. So there's been a sense of misplaced optimism, we would say. The other reason is that the pressures that usually push companies to go into liquidation haven't really come on yet. And what I mean by that is there's no revenue enforcement. Very frequently companies go into liquidation because revenue have sent the sheriff, or they've put an attachment order on their bank account and effectively taken all of their cash. Or a landlord has put them under pressure and is looking to eject them from a premises. And of course, there were restrictions on landlords forfeiting leases there, which have since expired. Now, I see in the paper yesterday that there's a new bill coming in that's going to extend certainly the restrictions on residential forfeitures or evictions. We don't know where that's going to land for commercial properties. And of course, there's been no payroll pressure. So in ordinary times, if a company runs out of money, they can't pay the staff and they have to close. As things are running at the moment, companies are running out of money, but the state is paying the wages. And all of that, together with creditor goodwill, means that companies that might otherwise have gone into liquidation haven't taken that step just yet. So we'll move on a bit there and think about what that means for individual directors of companies. So go from the macro level down to the micro level. And in the picture here, I suppose you could take the view that the rock is companies' traditional trade creditors and the electricity and so on, electricity bills and payroll costs. And the bear is essentially the state, and people are running away from their usual trading expenses by using funds that are essentially being lent by the state, and they will, when these supports end, find themselves in the jaws of the bear when the warehouse tax debt comes due for repayment, and they find that they're no longer in a position to rely on the state to pay the staff. And they're in a situation of great uncertainty. So the questions that there's uncertainty around in most SMEs are, will we be open or shut next week, the week after that? Very importantly, will our debtors pay us? And in the context of 16% of SMEs being in financial distress, 70,000 of them relying on tax warehousing to keep going, there has to be great uncertainty over whether any company's debtor book is good. And a failure by debtors to pay is something that we expect is going to cause the insolvency of a lot of otherwise good companies. There's uncertainty around turnover. Nobody knows whether consumer spending is going to recover to levels that it was at before, and if it doesn't, then there's a huge number of businesses that are going to suffer for a permanent drop in turnover. And the most significant uncertainty is, will we be able to pay the debts that we're incurring now? And in that context, I'm really talking about debts that are being incurred to the revenue in terms of warehouse VAT and PAYE, debts that are being incurred to landlords where tenants have either had deferral of rent or simply haven't paid without getting an agreement with the landlord. And the question that directors of companies facing all of those certainties have to answer is whether their current insolvency is temporary or permanent. And of course, if it's a temporary position and they can reasonably project that all will come good in the fullness of time and that they'll get an opportunity to allow that happen, then it's reasonable for them to continue trading at the moment. But if it should be the case that there's no prospect or a very limited prospect of recovery, then they're looking at permanent insolvency. And the fear that they ought to have in that situation is whether they're trading recklessly or not. And what we mean by reckless trading is that they are either actively or passively allowing their company to incur debts that are unlikely to be repaid. And that's a serious issue, and can result in directors being made personally liable for debts that are incurred in those situations. And it's worth bearing in mind that if a director is made personally liable for their company's trading debts, then they will almost certainly also be disqualified from acting as a director. Now, we're going to do a poll about certainty and uncertainty that companies are facing, and then I'm going to hand over to Aisling, who's going to talk a bit more about reckless trading. So you should see on your screens there that a poll has come up, and we're asking the question, how confident are you that your business will be solvent in 12 months? And the options are very confident, uncertain but that you expect to be solvent, uncertain but you have some doubt, or that solvency is quite doubtful. So if we take a minute there or a few seconds to complete that poll. Aisling, I think while people are completing that, we can probably.
Yeah, absolutely. Yeah. Thank you for having me. And I suppose it's not everyone wants to spend a morning with their lawyer and their accountant, so I appreciate you joining. I suppose just to follow up on the first few parts of what Declan said in terms of the insolvency numbers being down. I think even generally across the disputes that are going to come as a result of COVID-19, be it insolvency, be it employee claims, be it property disputes, rent arrears case, we haven't seen that come yet for all of the reasons which Declan has mentioned, in terms of being padded up by the government and the goodwill that's there with creditors, which is no doubt at some point will run out. So even from a litigation point of view and disputes issues, we haven't seen those things come to a head yet, but there is, I think, no doubt in anyone who works in the area of litigation that next year is going to see a fallout from all of those things, insolvencies and disputes, in terms of probably in particular property and leases and that kind of thing is going to be certainly a massive disputed issue next year, and we're expecting that. Then I suppose, look, in terms of the particular point that Declan's talking about here, in terms of reckless trading, I mean, from a court's perspective, the court is, they're not expecting that on the first sign of economic distress that a company shuts up its doors. That's not what they expect. But they do have, I suppose, in a general sense, we need to proceed with caution, and be warned of what the sanctions are if we step over the bar in terms of caution into kind of mindlessly proceeding with a company that doesn't have much hope left in it. Reckless trading is, I suppose, the sanction that's there. It is a concern, and essentially the bar for reckless trading is about knowledge. So it's about what you know or what you should know because you are a director, and about taking steps that would cause a loss to your creditors. So it's about the knowledge of moving forward when you know the steps you take next is very likely to cause a problem for your creditors. The backdrop to being to a reckless trading allegation against you is obviously, as Declan's pointed out, is personal liability. I mean, that's the biggest fear, I think, probably among most directors, that's something that'll come after them. Reckless trading, in terms of actual court applications and what we see in terms of courts, in truth, there isn't a significant number of reckless trading cases that have come before the court and have got substantial analysis. There was a period of time where we had very little. In the last couple of years, we've had a few. One of those is a particular interesting case. Is the case of Appleyard Motors, which is it's not that, I think it's a 2019 case, and essentially in that case, a director chose. I'll probably actually get into more details in terms of it, but essentially the director in that case was by the High Court found out to be reckless trading, but then the Court of Appeal overturned it, and actually he wasn't found personally liable. That case comes up probably a bit more detail later, so I'm not going to deal with it twice. Another case is a case of PSA Construction, which again is a more recent case, and that one probably is one that might hammer home a bit more. In that one, a director essentially decided that he would underpay the revenue and use that money to keep his company afloat. It was a construction company based out of Naas in Kildare, and that was the decision was made, was he would underpay revenue and under-declare his revenue and use that money to keep the company afloat. What that resulted in then obviously is the company building up a significant arrears in revenue, which obviously resulted in a loss for other creditors, with the revenue being a preferential creditor. In that case, the director was found to be reckless trading and was found personally liable, and was found personally liable for the difference in the revenue debt, which was to the tune of 1.6 million. So I suppose reckless trading is there. The courts do implement it. They do carry forward in terms of personal liability. They do have a lot of discretion on that personal liability and how much of the debt they apply, but it's a real thing, and certainly it's the courts in the last number of years have started to implement it. So I think that what to take away from it is the court is not asking you to close your company because it's in a difficult financial position, but it's saying be careful with what steps you take next, and if you know what you're going to do is going to cause your creditors to lose money, then you shouldn't be doing it. I suppose is the simplified version of it. I mean, there's plenty more to talk about in reckless trading, but I think that gives you a flavour of the sanction that's out there.
Thanks, Ashley. I'll keep moving the slides on there, and I suppose with the scene set there, I think the the message that we should be getting out to people is now is the time to circle the wagons. And the most important thing to be doing at the moment is protecting directors so that they're in a position to continue trading, whether in their current corporate entity or in a future corporate entity going forward, and to avoid the risk that they get made personally liable for company debts. And the way we protect directors here is firstly by making sure that they act honestly and responsibly. And what that means we'll get into in more detail in a little bit, but in essence it means that you're complying with the Companies Act, that you're not contributing to your company's difficulties, that there isn't any want of commercial probity, and that's something that a liquidator will have to investigate and report to the ODC on, and potentially bring a restriction application if those issues arise in the context of a company that has been wound up. So in terms of practical measures, the question that follows then is how do you show that you have behaved honestly and responsibly? And the very first thing that directors absolutely must have is good management information. And what that really means is having up-to-date management accounts, because if you don't know what situation your company is in today, then it's impossible to make informed decisions either about what to do now or how to forecast for the future. And that gets us into forecasting. If a company is quite evidently in trouble from the results of management accounts, then if the directors want to keep trading into the future, then it's essential that they have a forecast prepared, and the forecast shows that they can trade into the future either profitably or in a way that won't result in greater losses to their creditors. And the way you do that is you document what would be received by each class of creditor in a liquidation scenario today, and then prepare your forecast and do the same exercise and say, well, what would they receive in a liquidation scenario at some point in the future? And even if it were the case that the creditors wouldn't receive all of the amounts that they're due to receive today, you can still continue trading, provided that your forecast shows that they will do better at some point in the future. But without the forecast, a decision to continue trading at a time when you're insolvent is an invitation to personal liability, restriction, and disqualification. And to, I suppose, further support a director's position in making that decision to continue trading, there should be documentation showing that there was a survival plan, and that it was considered and tested, and that it was only after giving the subject due consideration that the directors decided to continue. And that's something that directors would certainly be well served by bringing their accountants or their solicitors in to assist them with, so that there is a permanent record that a liquidator can refer to when making a recommendation to the ODCE, to show that this is an issue that was identified and taken seriously, and that whilst a decision was made and may have been the wrong decision with the benefit of hindsight, on the basis of the information that was available to the directors on the day, it seemed like a sound decision. The other thing that directors can do, and it's counterintuitive, is to make sure that their creditors know their position. So the tendency is to hide the fact of your financial difficulty from your creditors. And that's the wrong thing to do. The right thing to do, certainly with creditors who you're expecting to obtain further credit from, is to make sure that they're aware of your company's financial position, that it may take you longer than you expect to pay, that there's some element of risk involved. And if it should be the case that the company subsequently finds itself in liquidation and the creditor doesn't get paid, it is a defense to a reckless trading application to say that the creditors concerned were aware of the company's position and having considered that, advanced further credit anyway. The other thing to consider if a company is in significant difficulty and is insolvent is what we call the order of priority. And what we mean when we talk about the order of priority is there is a statutory order of precedence in which creditors get paid in the event of liquidation. So the revenue, the rates, the Department of Social Protection get paid first, unsecured creditors get paid last, and so on. And in the context of an insolvent company, the directors should be operating as though they're operating for the benefit of the creditors and giving the creditors the order of priority that they are entitled to. So if you have a situation where a company goes into liquidation and it has paid all of its unsecured creditors but paid none of its revenue debt, then or certainly none of its preferential debt, then that will be a ground for restriction. And I know in the current context with the tax warehousing situation where revenue have agreed to defer liabilities, that there might be some defense there, but where a decision is made to warehouse debt and thus make funds available to pay unsecured creditors, that decision must be made on the basis of some reasonable expectation of it being able to pay the revenue debt in the future. And then the other consideration here is Section 997A of the Tax Consolidation Act 1997. And what that provides for is in the event of a company going into liquidation, the PAYE that has been paid by the company is first allocated towards all of the employees other than the proprietary directors, and only then allocated towards the liabilities associated with the proprietary directors. So if you have a situation where over the past 3 years, the total PAYE bill was €1 million and 200,000 of it related to the proprietary directors, and at the date of liquidation, there's 200,000 of PAYE outstanding. In that situation, the revenue can levy that outstanding 200,000 on the directors personally. And that creates a risk around warehousing PAYE debt because in essence, directors, to the extent that they've had salaries that were taxed from the company, essentially the directors are personally guaranteeing the warehoused PAYE debt. And that should be a concern to directors, and there's issues around that. Now, maybe one of the solutions is don't be a shareholder, and if you're not a shareholder, you can't be a proprietary director. So maybe there's an argument for transferring shares in insolvent companies to somebody else to try and avoid Section 997A. But it's an issue that every director of a company that has a significant PAYE liability should be very alert to. Aisling.
Just to follow up on Declan's position there, in terms, I suppose, of the concept of honesty and responsibility, and direct, I mean, the kind of the legal backdrop to all of this in terms of decisions made and the duties on a director when they're in this position and how they should go about their business. I suppose the backdrop to all of that is the duties of a director, which were for a long time defined in very vague senses across various case law. But in 2014, those duties were put down on a statutory basis, and they're in black and white. And they're still conceptual, but they in themselves should provide the backdrop for when you're making decisions to consider whether you are meeting those duties in decisions you take forward, because these are the basis of everything. They're the basis of, if you face director's trading claim, if you face a restriction, disqualification, at the backdrop of all of that are core directors' duties, which apply across the board. And I suppose just as a reminder of those are, the director's duties are to act in good faith, to act honestly and responsibly, to act within your powers, to use the company property for the purpose of the company, and there is of course exceptions to that, to apply independent judgment, to avoid conflict of interests, to use due care, skill and diligence, and to have regard to shareholders' interests. So they're they're conceptual, as I say, but they're real, and I think they, as setting a frame of mind when you're making decisions, honesty and responsibility, good faith, all of those things should be within your backdrop when you're making decisions. As what I'm doing, is it good for me or is it good for shareholders, stakeholders? And I suppose in terms of those duties, they are owed to the company itself, to the stakeholders and those involved in the company, to shareholders. If you find a situation where your company then is in the realm of insolvency, then your duties extend beyond just to the company and the stakeholders, they extend to creditors. And at that point, you have to consider, are your steps in good faith, and are you acting honestly and responsibly with regard to your creditors, not just your own company. So the duties extend as soon as you find yourself in a difficult trading position. In terms of those directors' duties, as I say, they're now on a statutory basis. Just one thing to mention in terms of that is the duties of a director before were thought to only apply to those who are active directors, and now and where you had non-executive directors, it was felt that there would be more leniency towards those duties and whether there should be any sanctions against non-executive passive directors. That is gone completely now, and in terms of this situation where you have an SME that has a husband and wife, and the wife adopts, not to kind of pigeonhole it in a situation, but I suppose generally in terms of a passive director, that they would not be involved in the day-to-day business. That's gone because that was used in a situation where we needed 2 directors to have a company. That's not the case anymore. And if you are in a situation where you have a passive non-executive director, then I would suggest that you have that director resign if they're not actively involved, because you no longer need 2 directors. And the risk that you do by maintaining that person is that person has all of the duties of a director, the same as an executive director. And the court has come out in a recent case to confirm that, in a case of Walfab's 2016 case, and basically said there's no leniency for passive directors. So if you're there and you're not actively involved in the company, but you're on the CRO, you are a director, you need to be warned that you take all of the responsibility of being a director. So I'd suggest maybe relook at your directorships if you are in that situation, especially where you're in difficult financial position and there is risks of sanctions potentially down the road. So I'd suggest to act now and deal with your directorships now to take that person out of the loop, because they're not needed now. Just one final thing, and I know I want to move on to the next thing. One final thing in terms of directors' duties. The ODC have brought out the Office of Director Corporate Forces have brought out a statement, essentially in regard to directors' duties and during the time of COVID. And essentially what they're saying is, look, there's no forgiveness. Your duties are your duties. If you're in economic financial difficulty, if anything, your duties are more live than beforehand. But what the ODC do say is, look, we're aware that the COVID situation is there. We are aware of the problems that companies are facing, and they're suggesting to look at things in terms, and I know Declan has mentioned it, but it's very, I think it's to get it home in terms of documenting things. If you're making decisions, document them, analyze them. Look at your projections. Look at how you might deal with things. Don't be afraid to acknowledge that you have an insolvency issue. I mean, that is key. It's putting the head in the sand is the problem that we face. So in terms of having your meetings, documenting, analyzing them, meeting with your solicitor or with your accountant, and that is a particular thing the ODC put in as a benchmark to show that you have thought about this and you've thought, can I survive, can't I survive, and I suppose that's a particular thing they look at. They look at the time in terms of the length of time you've traded after you're in this potentially insolvent position, and whether it was justified and reasonable to continue to trade during that period. As I say, the ODC are not saying your duties are forgiven, but they're saying, look, we're aware there's a bigger picture, and there is ways you can protect yourself. And I think the issue of honesty, responsibility, and the issue of documenting and acknowledging your problems is probably core to all of that, and that will provide you some protection down the road should you face an application by a liquidator or by the ODC in terms of disqualification or restriction. I think that's probably enough said on that.
Okay. I think we'll move on then, and then talk about what happens if it doesn't work out and you have to liquidate your company, or if you decide that you've simply decided to move on, wind up today, start trading again, when circumstances have improved. What are the potential sanctions that might make life difficult in doing that? So we're going to just list them off here, and then we go through them in a small amount of detail, but we'll probably go quite quickly through them. We've restriction, we have disqualification, personal liability, and reputational damage. And I'll move forward from there straight on to restriction. And restriction is I suppose the basic level of sanction that can arise in an insolvent liquidation scenario. And the liquidator is obliged to apply to the High Court for an order that the directors of an insolvent company be restricted unless he is relieved of that obligation by the ODCE. And the ODCE makes a decision on whether or not to relieve the liquidator on the basis of a report that the ODC receives from the liquidator. The liquidator's report will go into the background to the liquidation, to the reasons for it, and the director's conduct in the period running up to the winding up. And indeed, if there's serious misconduct further into the past, that might be dealt with as well. So that's how the ODC makes their decision. In over 90% of cases, the ODCE follows the opinion of the liquidator. And in that regard, when somebody's picking a liquidator, it's useful to have a liquidator, I suppose, who has a broad spectrum of conduct that he's examined in the past. So if you've somebody who hasn't an awful lot of experience as a liquidator, and they see conduct that is perhaps doubtful, but on a bigger scale, maybe less blameworthy, they might be more inclined to form the opinion that restriction is appropriate. Whereas if you have a liquidator who's dealt with serious misconduct in the past, then and serious misconduct, to the extent that the directors were convicted of fraud, perhaps, then that liquidator's spectrum of good behavior through to very bad behavior is much wider, and where the honest director who has made simple mistakes will fall in that spectrum is almost certainly going to be closer to the recommendation that no restriction be applied for. So the liquidator is obliged to restrict unless relieved from the ODCE. The people who are affected by this are all of the directors of the company who held office in the 12 months prior to the winding up commencing. And that leads back to Aisling's point of a moment ago, where if you have a husband and wife company, there might be a certain logic to having one of them resign to remove them from the scope of a restriction application. The grounds on which restriction can be recommended are non-compliance with the Companies Act, causing an increase to the creditor's losses, whether deliberately or accidentally or inadvertently. It doesn't matter if the director's conduct or their failure to act in a certain way resulted in an increase in losses, then they are within the scope of restriction. And then obviously dishonesty or a want of commercial probity is also grounds for restriction. And it's worthwhile just looking at what the consequences of restriction are. So a person who is a restricted director may not be a director or an officer of any other company for a period of 5 years unless that other company has a paid up share capital of 100,000 euros. So unless you have 100,000 available to you that you're willing to risk in a new venture, a restriction order is as good as a disqualification order. I'm sure Aisling is going to mention this, but the burden of proof in an application to restrict a director is reversed. The court will presume that the director was dishonest or irresponsible unless they can prove otherwise. So you don't go in facing a situation where the liquidator has to prove you were irresponsible. You have to prove that you were responsible. And before I know Aisling has a few things to say on that, but before I hand over, I know we have a poll here, and we might just flash that up now. I think we have a poll here. Oh, there we go. So these are the questions that I suppose we're interested in here in the context of having these things done will mitigate your risk of restriction. So do you have your management accounts up to date? Do you have financial forecasts that show that you can trade profitably into the future? And have you minuted meetings of directors, or do you have correspondence with your solicitors or accountants showing that you've had discussions around your future solvency and what the impact of continuing to trade with your creditors is going to be? So I'll give you a minute there to complete that. And you can click you can click all or none or any selection of these options. Aisling, do you want to go ahead?
Yeah, sure. To in on Declan's point, and obviously, I mean, in terms of where a recommendation is to go ahead with an application for a restriction, I suppose each application is based on its own facts, and there's no set bar as to what it might be, but certainly the circumstances around it are relevant on each particular case. What you could generally comment on in terms of restriction application is that we're not talking about situations of bad commercial judgment or misjudgment. We're talking more in situations where we have an element maybe of incompetence or negligence in the decisions that are being made. And I suppose when the court application is brought, exactly as Declan has pointed out, that the court must impose the 5-year restriction unless the director can prove otherwise. So that in itself is the reverse of the way many other cases, or the majority of other cases, are dealt before the court. Where in this case we have the applicant or the claimant, who is, if we call him claimant in terms of the liquidator or the ODC, and they're making the allegation, but the director must disprove that allegation, is essentially it. And the key to that disproving is this, again, concept of honesty and responsibility, and that is the key to it, in terms of that's how you defend this case, to say your actions were done in honesty and responsibility. The issue in terms of a director who faces himself with the potential of a restriction application. I mean, in terms of restriction cases, it's a real risk, I suppose. We may talk about disqualification, talk about reckless trading, and their cases there isn't, we don't see them before the courts as much. Reckless trading is a real risk, or sorry, restriction orders are a real risk. They go before the court regularly, and there is a raft of case law on them. So it's not a pie in the sky concept. It does happen, and it's real. responsible. There is, I suppose, there's I suppose the original case in terms of setting down what criteria a court would look at when they have a director in front of them who there is an allegation in terms of restriction, is a case of La Moselle, which is a 1998 case, but it is, and it has been expanded and adopted and formulated, but it still is the basis. And even when I mentioned it to Declan yesterday, he the La Moselle case, he said, look, that's what we use in terms of criteria. So again, it's not conceptual, it's real, it's what looked at by when assessing whether a recommendation should be made. I'll quickly go through this, I'm conscious in terms of time, but the La Moselle criteria basically says that a director has not complied with the criteria looked at is, have they complied with Companies Act? Have they done actions that are incompetent or irresponsible? What is the extent of their responsibility for the insolvency? What is their responsibility for the deficiency in the assets? And have they displayed an element of commercial probity? Now, there is an extension of that where we add in fiduciary duties, and that goes on in terms of loyalty, but they're the basis of what Declan looks at if there's a suggestion that there is somebody should be made, should be restricted, and it's also what the court look at. So they're the criteria that are considered. I suppose there's a raft of case laws, I say. One which I might mention is a case of Ray Logistics, which is the 2009 case, but the terminology used in that, I think, is good to get people thinking in terms of what way they should act. I mean, the court in that case basically describes and says, look, a director should not proceed to trade where to do so would be willful self-delusion. So don't be convincing yourself that this is the right step to continue because of your personal commitment to a business in a situation where there's no real expectation that the company could survive.
I think actually personal
so
self-delusion is something we see an awful lot of.
Yeah, and I think that, and the court has spotted that and said, look, and there's an emotional aspect to this. These are, especially in the realm of SME, these are companies that have been built up, but there has to be an effort to kind of separate yourself from that. I suppose in terms of, I might just give you one or two examples of factual situations that have resulted in restrictions, just that they might sit with you in terms of actions you might take in your own company. Ones that have been deemed irresponsible are, which have resulted in restriction orders against directors, or failure to make annual returns. That's the case of Walfab. The personal use of a credit card in that situation by a non-executive director, and it wasn't that they was used for personal reasons. Yes, that is the case, but the reason was that it could not be justified as to why she had used it, and that was the case of Zucchini Restaurant. There is a failure to keep sufficiently detailed books, which have failed to allow a liquidator then to establish the true financial position of a company. That was, again, the director was restricted. Failure to discharge tax liabilities and to use that money to keep a company afloat. It was in a case I mentioned, and there's also another case on that. And another example would be a company that transferred its assets out of its company into a related company, but there was no commercial reason to do it, and on that basis the director was restricted. So I suppose that what to take home from the restriction side of things is it does happen, and there is a lot of applications before the court with regard to restrictions applications, and it's something to bear in mind. Okay. If you can, I'll let you move on from there.
Rightio, we go on. We do a quick whistle-stop tour of disqualification, which I mentioned there, and disqualification is the next step on from restriction, and generally is something that requires serious misconduct and active rather than passive misconduct. So the liquidator may apply to disqualify a company's directors for a wide range of forms of misconduct, and they really are, I suppose, the same forms of misconduct that would justify a restriction, only graver in their form. But it is a discretionary application. The liquidator is never obliged to make that application, and in those circumstances, a liquidator who has sympathy for the directors and their position is very unlikely to make that application, and that brings, I suppose, forward the need for cooperation with the liquidator if one is appointed. It applies to all directors. It doesn't just apply to those who were involved in running the company in the year prior to the winding up commenced. And the minimum period of disqualification is for 5 years, although very frequently disqualifications or orders are made for much longer periods. I think I saw one recently for 20 years, and that would be one of the longer periods. But in that particular case, the judge said he was making a 20-year disqualification order because of the age of the director, and if the director had been younger, it would have been a longer period. His intention was to disqualify him for life. I'm conscious we're tight on time. Aisling, do you want to, and this is something that probably we're not going to deal with very frequently.
No, exactly. And I don't think there's much really to add on that. And it has to be kind of an element of serious misconduct. The only thing I would add in terms of this, in terms of exactly as you mentioned, Declan, in terms of the discretion that you have in terms of your recommendation to ODC, the same discretion follows forward into the court. The court has a discretion where it doesn't put restriction in terms of a disqualification application. The court has a discretion not to disqualify a director on the basis of the case before them and actually apply a restriction instead. So there is a bit of movement. If you face a disqualification, you may end up with a restriction. The only other small point to add on that is to keep us on our toes. With disqualification, the onus is reversed. So in terms of a court application, the onus is on the claimant or applicant, the ODC or the liquidator, to prove the disqualification rather than on the director to prove they shouldn't be disqualified. So that just is the reverse of restriction. But I don't think there's much more to say on that.
No, I don't think so.
It's there.
Yep. Okay. So we move on then to personal liability. We've mentioned it already in the context of reckless trading, but there are other circumstances in which a liquidator can apply to the court for an order making the director personally liable for the debts of a company. And again, there's no compunction, there's no obligation on the liquidator to make these applications ever. But where grounds exist, certainly it's likely that they'll be under pressure from creditors to make the application. And if there's no funds in the company, it may very well be that the liquidator needs the personal liability order to get his own fees or her own fees paid. So that's also a consideration. There are a few grounds on which a director could be made personally liable for a company's debts. As I said, one of the ones that people should be very much alive to is a failure to keep proper books and records is grounds in the Act for being made liable for up to the entire of a company's debts. Now, in practice, the courts will limit the extent that a director is made personally liable to the extent to which the failure to keep proper books and records contributed to the insolvency or contributed to the increased cost of the liquidation. But nonetheless, that could be a very large sum. I suppose if you're not in a position to keep proper books and records, then really consideration should be given to ceasing trade, bringing them up to date, and just liquidating. Reckless trading, of course, is grounds for personal liability, and fraudulent trading, which is much rarer, and I don't think we need to go into that today, is also grounds for personal liability. I think it's worth saying applications to make directors personally liable for company debts are quite rare. They don't happen unless there's a good prospect of recovering from the directors, and more frequently than not, they're settled outside of court because the liquidator doesn't have the enthusiasm for a contested battle where a check is waved in front of him by a director who's the subject of one of these applications. I don't think there's a lot to say on that, Aisling. Do you want to?
No. Oh, I mean, no, exactly that. I mean, look, in terms of the test, look, in terms of personal liability, it's a high standard test for the courts to actually apply. And I think the part that needs to be kind of acknowledged is the fact that it's the director ought to have known that what he did was going to cause a loss. So it's not, he considered it or it was a reasonable prospect. He knew that what he did now caused a loss to creditors. So again, it's back to knowledge, but it's about actual knowledge when it comes to personal liability, and just to say yes, in terms of the discretion is there for the courts as to what level that personal liability, for how much of the debt should they be accounted for, and that obviously depends on the facts, but the discretion is there for the court.
Absolutely. Yep. I'm going to move up on and very, very quickly deal with the question of when winding up is necessary. And I suppose you can see from the picture here that the real message here is when you're in a hole, just stop digging. Essentially, the answer is you must wind up a company when creditors can't be paid. Unless, of course, you have a situation where continuing to trade will improve that position. But if continuing will reduce the funds available for creditors, then the right decision for directors to make is to wind up the company immediately. Some of the considerations that you should be there, it may well be that you have a company that has paid all of its current debts and has ceased trading, but you have employees there who need to be made redundant. Those employee claims won't be funded out of the company, can only be funded by the Department of Social Protection, and a liquidator needs to be appointed to deal with that. So that's one situation where it sometimes occurs that directors don't wind up, and that ends up having serious consequences for them. And certainly I did a case a number of years back where the company had paid all of its debts except for the redundancy and so on. SIP2 represented the employees. SIP2 organised a petition to wind up the company. I was appointed, dealt with the employee claims, and ultimately I made restriction and disqualification applications against the directors because they had failed to wind up when they knew they ought to have done that. And of course, failure to wind up in a timely way is certainly a grounds for restriction. Aisling, before we get on to the alternatives to winding up, is there anything you'd add to that?
No, I mean, I suppose just a general kind of thought on it. I mean, one thing which before you make your decision to wrap up and wind up the company, one thing which is very, I suppose, getting a lot of attention at the minute is the concept of business interruption insurance. It's not relation to insolvency, but before you make your decision to go that way, check whether you have any insurance cover that might deal with your losses during that period. There's a raft of ongoing litigation with Irish insurers over at the minute, but check it. And if there is a potential that there is one there, maybe take advice as to whether that's something it could cover. And that's really just before you make your decision to say, right, I'm winding up, we're done here. So I think that's, I mean, in terms of employees and all of that, I mean, look, there's lots of issues regarding employees at the minute in terms of reducing wages, layoffs, redundancies, and there's a whole other webinar on that, to be frank. But I think that just the only thing to say on that is communicate, engage. If you're making decisions to wind up your company, talk to your employees, engage with them. Don't just deliver the information without engagement. As I say, there's plenty more on that, but just that's a brief comment on it is all I can say.
Okie dokie. We'll move on to then your alternatives to winding up, and we've got a picture of Gloria Gaynor here. If you're of a move to say, well, I'm going to survive through this. I'm in difficulty, but I want to survive. Then there are a few approaches that you can take. The first one is obviously, and it's the most common one in small companies, is the directors can support the company, and that can be a good idea, it can be a bad idea, but we'll talk more on it in a moment. There is scope potentially for informal compromise with directors, and then there's two forms of scheme of arrangement that are relevant in the context of SMEs, and we're going to just move quickly on towards them. Obviously, the instinctive reaction of many company directors when their company is short of cash is to provide support themselves. But before that's done, there really is a need to consider whether you've got a cash flow situation or an overall viability situation. And if it's an overall viability situation, then directors really need to consider whether it makes any sense for them to feed their zombie company, given that the likelihood is the company's going to be wound up irregardless, and the funds that they've advanced are simply going to be lost. On the other hand, if it's just a cash flow problem and maybe you have a valuable property with equity in the building that can't be converted to cash immediately, there might be a logic and there might be a reasonable prospect of getting your money back. But the real message that we'd be trying to get across to people here is, if your company is utterly insolvent and you're considering putting funds into it, then it is essential that you get some quid pro quo from the creditors in terms of a write down, because there's no point funding and getting nothing back for yourself. And that brings us into the formal and informal schemes of arrangement. And what a scheme of arrangement is it's a procedure whereby the company's creditors and the company agree a compromise on a global level, and all of the company's creditors are bound into that compromise. So we've two types of schemes that we want to talk about. The first one is what's called a Part 9 scheme of arrangement, which has some similarities with examinership, but is not exactly the same thing. And a Part 9 scheme of arrangement can be commenced by the directors without any court intervention. But if the company is under particular pressure at the time it wants to start the ball rolling, they can apply to the court for protection from their creditors. Unlike in an examinership, there's no requirement for an independent accountant's report. There's no requirement to show a reasonable prospect of survival, and the protection is relatively easily obtained. Having started the process, the proposals need to be formulated and put to the creditors. And the creditors look at them as separate classes. So your preferential creditors might get one proposal, maybe they're getting 100% of their debt paid either immediately or in time. The unsecured creditors might be getting 10% of their debt paid, and the connected parties might be getting 0% of their debt paid. So each class can have separate terms. The scheme is approved by convening meetings of each class of creditor, and it can be sanctioned if 75% by value and 50% by number of the creditors who attend those meetings vote in favor. And there's a couple of considerations here. The most important one is it's only the creditors who trouble themselves to attend the meetings who participate in that decision. And so the 75% by value bar might seem very high, but in the context of it being those at the meeting who are relevant, it might not be so high. In that very often a company will have a number of creditors who it has good relationships with, and who, if they're asked to come and support a scheme, they will do that. When the notice of the meeting goes out, the other creditors, there's a very strong likelihood that the majority of creditors will treat it in precisely the same way they treat an invitation to a winding up creditors meeting, and will simply ignore it. But notwithstanding that, the scheme still has to be fair, because after it has been approved by the creditors, it's necessary to go to the court and ask the court to sanction it. And generally, the court will sanction those schemes unless they are opposed, and the opposing creditor will do less well out of the scheme than they would out of a liquidation. So that's the bar. All creditors must do at least as well out of the scheme as they would out of a liquidation. Ashley, do you want to jump in on that?
Yeah, just briefly. I mean, in terms of this kind of the concept of it's essentially a debt compromise agreement that then gets the rubber stamp of the court, that in a kind of a general sense, that's what it is. There is benefits to it over, it's comparable to examinership, but there is benefits to it. And I think one of those which might be of particular interest is the fact that there's no investigation into the company affairs. So you will reach your scheme of arrangement. There's no probity. There's no independent auditor's report. There's no going to the court to justify that this company can continue trading. That can all be done internally. And I suppose it's and then you have your arrangement, and it's then rubber stamped by the court, which means then you have a legally binding agreement with those creditors that maybe didn't want to be bound by it. I suppose the other thing to say to it in terms of it offers cost efficiency and it offers speed. In terms of cost efficiency, you don't have your application to court where you're proving your company is still can trade into the future. You don't have your independence report, and you by right and assuming that it's a straightforward application, you have one application into court where you produce a pre-prepared scheme of arrangement to the court. The court's application in that sense, I mean, they will approve on the majority of scheme of arrangements, and there is certain criteria which I don't think we have the time to go into, but certainly essentially unless there's coercion or classes of creditors haven't been dealt with right, the scheme will be approved. In terms
Actually, I think would it be fair to say that the most important takeaway from this is if a scheme of arrangement is something that you might be considering, that you should move earlier. It's essential that you don't wait until the goodwill that the creditors have towards you is completely exhausted.
Absolutely, because with your percentages that you require, you need goodwill to get this over the line. And you know, so absolutely, don't run out of steam on it. Absolutely, and wear down your friendly creditors, as they say. One thing which, I mean, in terms of speed on it, there was a case in 2019 which did a scheme of arrangement, a pretty considerable scheme of arrangement, and from start to finish that took 6 weeks, which is pretty unusual for any kind of court application. Mm-hmm. From the day they issue their application to the court to the day they got it rubber stamped, that's quick, versus any other of your options in terms of court approval and legally binding. So just in terms of the speed and the cost, I think the Part 9s definitely give you that, combined with the fact you get a legally binding arrangement.
Yeah, and I think that's a huge advantage over examinership. Something that's done in 6 weeks inevitably costs significantly less than something that usually takes 6 or 9 months to make happen. And I suppose on the cost front, that really brings us into the Part 11 schemes of arrangement, which are an even simpler scheme that could be considered. These are much less formal schemes. They don't involve any court intervention in the ordinary course. But they still operate in the same way, in that a scheme can be put to your creditors as body, and if the creditors are agreeable to the scheme, or a majority of the creditors are agreeable to the scheme, it becomes binding on all of them. The difference between a Part 11 scheme and a Part 9 scheme is largely in the way that it's approved, in the sense that instead of having separate class meetings, you need to get 75% by number and value of all of your creditors to agree to this type of scheme. So it's more likely to be useful in the case of a small company with a relatively small number of creditors, where the majority of them are reasonably friendly or can be paid down to a certain level prior to the scheme. And what's required here is your scheme might involve all of the preferentials being paid in full, and I think they'll have to be to get revenue agreement, which you'll need, given that you need your 75%, and your unsecured creditors may be getting 10 cents in the euro. But as an approach, by comparison with the Part 9 scheme, this is even faster. It doesn't require physical meetings. Everything can be done by exchange of correspondence. And if you're in a position to go and have a conversation with your creditors and agree something in principle with them, this can be a good way of bolting the belligerent creditors who won't agree to anything into the scheme that the other creditors would agree to without any great difficulty. The big downside of this type of scheme is that it needs 75% of all creditors to get involved. So if you have creditors who are disengaged and simply won't react either in a positive or a negative way, and those creditors come to more than 25% of your overall, then you can't move this along. But I think it would be rare enough to have more than 25% of your creditors, be either number or value, who simply won't engage. They'll either be in favor or not be in favor. And if they're not in favor, then there's no reason you can't do a side deal with them that's somewhat better than all of the other creditors are getting. Aisling, do you want to say anything on that?
In terms of from our perspective, there's very little court involvement in these cases, very much a legal involvement in them. So I don't have a whole lot to say other than the way these Part 11 schemes come before the court is where you have a creditor who's not happy with the arrangement, and they make an application to the court to have that amended, varied, and that's where it comes before the court. And those applications are few and far between at the minute. But so certainly there isn't much more from the court's perspective to comment on it, because they don't require court sanction, and they're more of a debt compromise, a very informal compromise, with probably, as Declan points out, maybe where you don't have a significant number of creditors.
Yeah, okay. The last form of compromise that we're going to talk about is the one that people most typically do. It's an informal compromise where there's no formal scheme. Generally they're not documented to any great extent, and directors go about and have their individual conversations with their creditors and do individual deals with them. They're great where they work. There's no need to have the same terms applied to all the creditors. You probably don't need any professional advisors. But the big problem with them is you might be able to do deals with 8 out of 10 creditors, but you could be left with 2 belligerent creditors who simply won't do any deal with you. It's unfair, I would argue, to your other creditors to treat those 2 belligerents in a much more favorable way. So we would encourage people to be wary of going about that sort of informal individual compromise, because the effect of it is, if you've already done a deal with 8 out of 10 creditors, then you've lost the voting constituency who will vote in favor of a scheme that might write down the other 2. Far better to go about the 80% of creditors who will do a deal with you and say to them, we're not going to formalize the deal today. The deal will be formalized as part of a Part 11 scheme, so that everybody is dealt with on the same terms. And certainly our experience is that creditors are very open to a scheme that sees all creditors being treated in the same way, or certainly in accordance with the order of priority, because nobody likes to be the one who took the 50% haircut when the fellow standing beside them was a holdout and got 100%. It doesn't leave people with a good feeling in their mouth. So if you have to go and do a scheme, or if you have to go and do compromises, keep Part 11 at the back of your mind. If you think Part 11 is impractical in the context of the number of creditors that you have, and the ability to engage with all of them, then Part 9 should be something that you think about. I'm conscious we're tight on time. We've run over. I might move on a few slides rather than doing everything that's on the list, and just talk about life after liquidation. And it's important for people to think about, if they do have to wind up their company, their troubles in 99% of cases relating to that company end on the day the liquidator is appointed. The phone calls from creditors stop, you sleep easy, and you move on with your life. And the responsibility for dealing with all of the issues that were in the past for you falls on the liquidator, and that's what they're paid to do and familiar with doing. There's nothing in the world to prevent a director starting a new business the day after his old business goes into liquidation. There's a popular misconception that there's some restraint on directors doing that. There is not. And liquidators in particular are familiar with directors doing that all the time. And as long as it's done in a way that doesn't negatively impact on the creditors of your old company, there's no issue with that. There's no issue equally with buying the assets of your old company from the liquidator, as long as that transaction is done at arm's length. And the liquidator of your old company may even continue the business of the company after it goes into liquidation for a period of a short number of weeks to facilitate that happening. Extraordinarily, and you might not believe it, that sort of an arrangement can actually result in creditors doing better than they would do otherwise, because if you take the employees into a new business, having liquidated the old, 2P will apply, so the redundancy bill that would otherwise dilute the amount the creditors in the old company would get doesn't arise. And because of that, this is something that if it's put to the revenue and other significant creditors in a way that's transparent and doesn't seem to be hiding anything, and the transaction is clearly at arm's value, revenue and other seasoned creditors are enthusiastic about this and will give it their blessing. Their blessing isn't needed, but it's nice to have. Now, we go to questions, Aisling?
Yes, go for it, yeah.
Denise, do you have questions for us?
Yeah, just bear with me 1 second. A few questions have come in here during the seminar, so thank you all for staying with us. I'm aware of time, so we'll just get through a few here. So the question here, how does a liquidator determine arm's length, and can it be a debatable and slow process where land is involved?
Where land is involved, it can be probably a slower process, but in most cases, you're talking about the sale of trading assets, you're talking about the sale of goodwill, and maybe debtors, things like that. In practice, if you know in advance that you're going to be appointed as liquidator of a company, it's possible to arrange for, you know, a sales proposal or an information memorandum to be prepared and ready on the day the winding up commences. So if the winding up commences on a Friday morning, the advertisement offering the business for sale can be in the Sunday newspapers. And then you could have a 2-week sale process. So 2 weeks later, you've received best bids. The liquidator accepts the best bid he has for the goodwill and the trade of the company as a going concern. Now, of course, the liquidator has to be seen to have obtained more on that basis than he might get on a breakup basis where he sells the assets individually, and the test as to how he might do in that situation could be easily dealt with by getting an industrial auctioneer in to value the assets. But it's very rare that you can do better selling the assets in liquidation individually than you would on a sale of a going concern. Where land is concerned, really an auction is the ideal. But if you have your 2 or 3 qualified valuers reports, and they're all coming in at around the same level, then an off-market transaction can be done. But if you're going to do an off-market transaction, then you need to get the committee of inspection or the creditors generally to, you need to give them the opportunity to object to it. It's very rare you get an objection. And an objection can't be sustained unless there's a better offer available. Liquidator isn't obliged to wait forever to sell something.
Okay, thanks, Declan. And just I'll just take one final question here. Is there a redundancy cost saving from a liquidation for a company?
Well, I suppose if all of the staff are being made redundant, the cost of funding that redundancy is the same regardless of the circumstances that the redundancy arises in. But if the company is in the course of being wound up, then the liquidator can apply to the Department of Social Protection for funds to pay to the employees. The employees get their money immediately. The Department of Social Protection then stands in as a creditor in the place of the employees. So it's not so much that there's a saving; it's that the state will make funds available to pay the redundancy bills.
That's great, Declan. Thanks. I might leave the questions there for today. I just want to take this opportunity to thank everyone for their time this morning, and to thank our speakers, to thank Aisling for joining us from O'Shea Barry, and to thank Declan DeLacy. And if you have any further questions, you can pass them on to myself or any of the speakers. Their email addresses should be there on the screen, and they'll be happy to come back to you on anything else. Just while I have you all there, just a quick note, we'll be hosting another seminar, another webinar at the early December with David Lucas, our corporate finance partner. So just keep an eye out for the invitation for that. And also just to mention that we launched our PKF OCLH app earlier on in the month. The links are there as well to download it. So just a shameless plug there. So I'll pass you back across to Donal to finish up, and just thanks again to you all for your time.
Very good, Denise. Thank you very much for organising it, and thanks to our participants this morning. Aisling in particular for joining in and giving us some very worthwhile commentary on the proceedings. I think it's very interesting there what Declan and Aisling were discussing. And again, both of them are available offline if anyone wants to send any questions or pick up the phone and talk to us. These are difficult times, and these are big issues that need to be continually reviewed and make sure that you're making the right and correct decisions at all times. So thanks to everyone for joining us. As Denise said, we'll have another seminar at the start of December where David Lucas will talk about raising finance, what's available, and potentially looking at selling your business if that is an option at this time. So thanks to everyone and have a good day.